This video is intended to familiarize you with the court procedures and does not offer legal advice. The court assumes no responsibility for actions taken by the viewer of this video. For further assistance in filing for a default, you can attend a once-a-month free workshop presented by highly skilled staff members. See the Superior Court website for workshop date and times. You may need to ask the court to enter a default decree in your family court case when you filed a summons and petition for one of the following: divorce, legal separation, annulment, to establish paternity, or to establish a first court order for custody, visitation, parenting time, and support. And the other party was served with the court papers. Proof of service has been filed with the clerk of court. And the other party has not filed a written response or answer within the time frame set by law. Consult the default timetable located in the procedures paperwork. It will list the number of calendar days to count before you can apply for a default hearing or order. Begin counting the day after the party was served with the petition. Include weekends and holidays. If the last day for the party to respond falls on the weekend or legal holiday, do not count that day. If the other party did not file an answer or response with the court, you may complete and file the application affidavit for default with the clerk of the court and mail a copy to the other party. This video will list the steps you must take to have a default decree entered in family court, including forms you need to complete, where to find the required forms, filing the documents with the clerk, giving legal notice or service, and what to expect at the court hearing. You can pick up the documents from the Self-Service Center or print them online. Fill out the application affidavit for default in family court cases. You must do this if you want your case to move forward. When the time shown in the default timetable has passed, sign and date the application. You will need to make 2 copies of the application and affidavit for default. After preparing the application affidavit for default, you will need to bring the original documents and 2 sets of copies to the clerk of court. There are 4 locations at the Superior Court in Maricopa County: Central Court Building, 201 West Jefferson, Phoenix, Arizona, 85003, Northeast, 18380 North 40th Street, Northwest, 14264 West Terra Buena Lane, Southeast, 222 East Javelina, first floor. There are fees for filing petitions, responses, requests, motions, objections, and various forms with the court. Go online or to the Self-Service Center to determine if there are fees associated with the document you're going to file. If you need to have a certified copy of your decree the day of your hearing, please make that known during your court proceeding. Please check the Clerk of Court website for fee amounts. Cash, Visa and MasterCard debit or credit cards, money order, or a personal in-state check made payable to the Clerk of Court are all acceptable forms of payment. Mail one of the date stamped copies of the application and affidavit for default to the other party on the same day you file the papers with the Clerk of Court. Keep the other copies for your records. The application and affidavit for default must be mailed. Hand delivery is not acceptable by the law. If there are no children involved in your case and you would like to proceed with getting your divorce or legal separation without having to go to court, you may qualify to apply for default without hearing. See the procedures on how to get a default decree without hearing at the Self-Service Center link. Count 10 business days starting from the day after the application affidavit for default was filed before calling for a hearing. During this time, you can fill out the default screening checklist to make sure you meet all of the requirements before scheduling your hearing. After you've filed your documents, paid the required fees, and given legal notice or service, it's time to request a hearing date. Schedule your default hearing by calling 602-372-3332 or go online and click Schedule Decree on Demand Hearing on the right. You will need the information from the default screening checklist with you when you schedule your hearing. You will need to bring the following documents to your court hearing: completed decree of dissolution, legal separation, or order of annulment, paternity order, or first court order along with 2 copies of the document. Completed and notarized service member civil act waiver if the other party is an active member of the United States military. A 9x12 envelope addressed to the other party with 4 standard current postage stamps. Failure to bring the required documents to your hearing can result in your hearing being vacated and rescheduled to a different day. Go to your hearing at the scheduled date and time. Family court default hearings are held at the following locations: Central Court Building, 201 West Jefferson, Phoenix, Arizona, 85003. Southeast Court, 222 East Javelina, Mesa, Arizona, 85210. Northeast Regional Center, 18380 North 40th Street, Phoenix, Arizona, 85032. In a default hearing, the court may grant requests made in the petition without the respondent's participation in the hearing. This is known as getting a default decree or judgment. In dissolution cases, a default hearing cannot be set for at least 60 days after the date the petition was served on the respondent. For further assistance in filing for a default, you can attend a once-a-month free workshop presented by highly skilled staff members. See the Superior Court website for workshop date and times. Consulting a lawyer before filing documents with the court may help prevent unexpected results. A list of lawyers you may hire to advise you on handling your own case or to perform specific tasks, as well as a list of court-approved mediators, can be found on the website.